OTIENDE.
Thank you, Chairman. Chairman, I agree with the difficulty you find yourself because you are not the substantive speaker when the mover was not called upon to respond, and it just adds to the litany of improprieties that we propagate as a House. But, Chairman, I rise under Standing Order 130E, and I will read it. Except as otherwise provided in these standing orders, the same rules of order and of debate for the conduct of business shall be observed in committee as in the House. My understanding, therefore, Chairman, is that whether or not there's an amendment, we as members are entitled to be heard on these matters. And on that account, I beg that I be heard on these matters.
The member who has just spoken, the Honorable Tiende, you are spot on, and that's why where we've reached so far in the agreement of the whole House is the time when I should now give you a chance to speak on what you want to speak on among all those clauses I've read. If you remember, I've said I've proposed all those clauses. So it's for you to consider those clauses by making comments on them. That is the stage we are at in the committee. And so the floor is open for any comments at this point.
So can I proceed? Can I proceed now?
Is it a point of order or you
No. Now on contribution as guided by you.
Correct. You go ahead now.
Thank you. Mr. Chairman, all these clauses as properly read by you are improper, they are irregular, they are for rejection in totality. I heard Honorable Mbui say that the National Assembly has become a house of bass, the Senate has become a house of soprano. If that is so, at this stage, we now must be at the alto stage, because clearly it is the same charade. Mr. Speaker, in fairness to Senate, at least they considered some amendments. And in fairness, they have endeavored slightly to try and improve one or two things, but they have still overall failed miserably. And the fact that even the Senate amendments are not being considered properly by this House shows that we and those who are propagating this whole idea are only interested in the funds, not in the why, not in the what, not in the how. Mr. Chairman, I want to say that the technical issues we raised on this affordable housing bill, the legal issues we raised, the policy issues still remain. They remain untouched. And to that extent, these amendments, it does not improve the original bill, and they are all for rejection. Let me just give one example and I sit down, Mr. Chairman. You see, when we raised the question of how the affordable housing relates to the counties, in this House, nobody wanted to hear that. At least in the Senate, they have endeavored to introduce a clause, Clause 31A, in which they are introducing what they call the County Affordable Housing Committee. But that committee, they then prescribe who's to be in it. And it begs two questions. One, if we agree that affordable housing generally is a mandate for the counties, then why are we prescribing and legislating for the counties how to execute their mandate? It means we are reprobating from the Constitution. Two, to establish a county committee, which then is subordinate and answerable to the National Housing Board, is to actually usurp the mandate of the county and place it at the national level. And that's just one example, Mr. Chairman. So what I want to say is this. All the policy issues, all the legal issues, all the technical issues still remain. And one day, if it is not the courts, then Kenyans will vindicate us. Thank you very much.
This is the Honorable Chepkonga.